The information provided on this show does not, and is not intended to, constitute legal advice. Instead, all information on this show is for general informational purposes only. The information provided is not a substitute for legal advice, and we recommend viewers consult an attorney for specific legal matters.
That's what we were talking about before we went to the break. So as I was saying, there's an industry-wide publication called the Florida Community Association Journal that condominium boards, HOA boards, and co-ops subscribe to throughout the state. Good publication. And each year they take surveys from their readers as to who's the best management company, who's the best landscape company, the accounting firm, lots of different types of industry things that they don't want to know how the co-ops and condos feel about the industry leaders in this regard.
And you're one of them.
Yes, and of course they do a take on law firms as well. And so I get a call from the editor a few weeks ago who says, Eric, I got some good news to share with you. What's the good news? The readers of the magazine gave Glazer and Sachs the most votes of any law firm in the entire state of Florida.
Wow.
Yeah. So that is beyond flattering. Actually, check this out. It was the second most votes of any business in the entire state, which was really, really flattering.
Who had the number one?
I have no idea, but number one law firm in the state.
Way to go.
So again, beyond flattering, I want to thank everybody out there who took the time out of their busy schedule to cast a vote for my firm. Very much appreciated. Thank you very much. All right, interesting article in the Miami Herald last week about the fact that an endless amount of condominiums out there who are required to have their structural integrity reserve study performed by December 31st, they still haven't done so.
So what's the repercussion?
Well, here's what the statute requires. If the officers or directors of an association willfully and knowingly fail to complete a structural integrity reserve study, such failure is a breach of the officer and director's fiduciary relationship to the owners.
Oh.
So to me, that's pretty serious. God forbid something happens because they didn't do a study.
Oh, so
to me, they breached their fiduciary duty. Anything happens, that's potential individual liability on them. But, does the statute say what the penalties are? No, not really. It really doesn't say it. But
and there's no real reporting hub where everyone, there's a place you can find out who has and who hasn't, or is there?
You're supposed to be reporting it to the DBPR. Yes,
okay,
you
so
are
there
required.
is a list
right.
there. Okay.
But the question is, all right, you got to report it. So what does it mean if you don't complete it? It really doesn't say in the statute.
Because you have endless amounts, but we don't know how many.
Yeah, there's thousands that still haven't reported, still haven't completed it.
Because there's 1.1 million that need to be done here in South Florida.
Right, exactly. Almost all, so many in the state are here.
Yeah.
It's not enough engineers to do it,
right.
not enough architects. But still, here we are now, 2 months past the deadline. If you haven't done it, you should have done it by now. I think you should have been able to complete it by now. There's just associations that, for whatever reason, they're behind, or maybe they just feel they're not going to do it. But what is the penalty?
Some people don't even pass a budget.
Right, exactly. But we'll see. We'll see what actually winds up happening with the DBPR. I can tell you, if somebody doesn't do it, how do you go about complaining about it? It's something that the unit owner has to rat on the association themselves by taking them to arbitration.
But why would the unit owner want to do that? Because they're going to end up paying more money.
They're going to wind up exactly being the ones paying the fine.
But if you go to sell, you have to disclose that you're in breach, right?
Go. As a matter of fact, Robert keeps telling me that we have to do a show on this next topic because it's so important and everybody's confused about what happens when you sell, even all the realtors. So here we go. What kind of disclosures need to be made when someone is selling their condominium unit?
Yeah, so there's different disclosure laws, and when it comes to commercial real estate as opposed to residential real estate,
big difference.
And realtors have to enter into an agreement and a contract.
Yes, exactly.
It's like a big
have a lot
deal.
to disclose, exactly. And when it comes to buying commercial real estate, it's always been, you heard the term caveat emptor, or let the buyer beware.
Yeah.
But when you're selling a residential condominium, it's anything but buyer beware. And it's more like the seller better disclose everything that they know and everything that they may know and should know. There's a lot that the seller has to disclose.
And no lying in the estoppel letter.
Absolutely.
All right. So with the new laws, buyers want to be careful about the condominium unit that they're buying, because you could get a real
You can get stuck
stinker.
owing a lot of money right off the bat.
And you want to make sure that you're not buying a unit that's going to cost you tens of thousands of dollars in extra special assessments. This is why the market is so screwed right now, because people aren't buying it because of this.
Yeah, and that's what every buyer's afraid of. So let's talk about everything that the buyer is supposed to get when the buyer signs a contract. So it's Florida Statute 718.5032A for those of you playing along at home, and it provides really a plethora of information that the buyer is entitled to when purchasing a residential condominium unit. Okay, now here's only part of the statute. And again, this is for non-developers, when a regular person just selling their unit. Each unit owner who is not a developer must comply with this subsection before the sale of his or her unit. Each prospective purchaser who has entered into a contract for the purchase of a condo unit is entitled to, at the seller's expense, a current copy of all of the following. Okay, so the buyer gets all of this at the seller's expense: the declaration, the articles, the bylaws, any annual financial statement and the budget of the association, a copy of the inspector-prepared summary of the milestone inspection report.
That seems like the only thing that's in addition, because the other things you still have to provide.
Right, correct, yes, and those should be easy to get as well.
Yeah.
The association's most recent structural integrity reserve study.
That's new.
Or a statement that the association has not completed a structural integrity reserve study. A copy of the inspection report.
Oh boy.
For a turnover inspection. The document entitled Frequently Asked Questions and Answers, required by 718.504. The prospective purchaser is also entitled to receive from the seller a copy of a governance form addressing the following subjects. Karen, tell them what that form covers.
Number one, the role of the board in conducting the day-to-day affairs of the association on behalf of and in the best interests of the owners, the board's responsibility to provide advance notice of board and membership meetings, the rights of owners to attend and speak at board and membership meetings, the responsibility of the board and of owners with respect to maintenance of the condominium property, responsibility of the board and owners to abide by the condominium documents. This chapter, rules adopted by the division and reasonable rules adopted by the board.
Yeah, again, this is all in one form about condominium governance. It's got to talk about owners' rights to inspect and copy the records.
Why do developers have to do it?
Developers have to do different disclosures, but this is for, again, right now, this is for, and think about it, there's a lot that the seller has to disclose here. Remedies available to owners with respect to actions by the board which may be abusive or beyond the board's power or authority. The right of the board to hire a management company. The responsibility of the owners with regards to payment of regular or special assessments necessary for the operation of the property. The voting rights of owners, rights and obligations of the board in enforcement of rules in the condo documents and rules adopted by the board. Think about it. If you never moved into a condominium before, these are all the things that you would need to know about how a condominium even works.
Right.
So this form, this question and answer form, is basically designed as if someone had never lived in a condo before. Here's what a condo is all about.
Does the realtor have this form? Who has the form?
The condo's supposed to have it.
Okay.
Yeah, and this form cannot be filled out, by the way, by the association's management company. Yeah, this is a form that needs to be filled out by the association's counsel. So make sure that you have it on hand, and it's a lot of information that the buyer is entitled to. And I'm sure most of you condo boards or even managers are shaking your head saying, you know, what in the world is this condominium governance form that Eric's talking about? If you want one, all you're going to have to do is go to our blog on this topic. We're going to have a link up there. If we don't have it up there already, I'm not sure if we do, but we will have it up there by tomorrow. And again, all condos are required to have this form as an official record on hand.
Well, that should be easy.
So-
It would just be the same for everyone.
Correct. The same form
So-
for everybody. Just make sure that you have it.
Yeah.
Not to have it is a violation of 718.
And that's something you would do.
Yeah, correct. It's got to be done by an attorney.
Okay.
Cannot be done by your management company. That's in effect practicing law.
And if the attorney sees that they haven't done the Sears,
They should.
and what would you do?
Well, if
Are you
I
gonna
knew
put
my
that on the
client blew
form?
the deadline,
Yeah.
what would I do if
Would
my
you put it
client-
on the form? They didn't do it?
You have no choice. You can't lie in the form either, right? But what would I do if I knew the client blew the deadline? Is a good question. I'd certainly cover my butt. Remember,
Yes.
I don't want a building falling on my watch while I'm the
Right.
attorney. So I'm gonna.
You would
know,
have a
make it
fiduciary
clear-
duty.
Yeah, I'm gonna make it really, really clear to them that the deadline was blown. You're risking the lives of everybody in the building by not doing it. I know I'm gonna cover myself that way. I can tell you for sure. And protect everybody in the building. But let's hear what our viewers have to say. Give us a call here in the studio, 717-GLAZER-8. That's 717-452-9378. Or drop us a question or comment in the chat box on YouTube, on the Condo Craze and HOAs channel. We'll be back right after this.
There are very large management companies and there are very small management companies. And I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
Welcome back to Condo Craze and HOAs here on our YouTube channel. Karen Curtis with attorney Eric Glazer. He is board certified in community association law, answering all your questions here. And if you didn't meet that deadline and blew it, he's going to give you a spanking.
When we came back from the break, I was going to just move my mouth with no sound coming out, but that would have been cruel to them, wouldn't it?
That would have been
Yeah,
mean.
that would have been mean. Anyway, okay, Eric Solenstein writes in, yeah, BOI was put off again. That's correct. The Corporate Transparency Act document that kept going on and off and on and off and on and off. Done. Finished. Forget about it. Don't bring it up anymore. It's done. The government's not going to make you do that.
Except you're writing for checks
Yeah.
for cash. Those of you who remember the $1,000 cash.
The Trump administration came out this week and said, very clearly, the whole idea was they want to make things easier for small businesses. There you go. This is one form that they're not making small business or any business for that matter fill out. So forget it. It's dead. We don't even have to talk about it anymore. For those of you who filed it, you filed it. What are you going to do? For those of you who paid to file it, what are you going to do? You paid to file it. Nothing you can do at this point. Good question, good comment by one of the comments on the board. It's from Stivmia, and it basically says that the requirement to do the Sears is going to be enforced by the insurance companies to a large degree. And I think that's very smart. That's a really good comment because, yeah, they're not going to do the issue you a new policy if they know you didn't do your structural integrity reserve study. I think that's really smart.
And any contract you have would be null and void, would it not?
What do you mean contract?
With the insurance company. if you don't do it.
Well, if they don't ask you for it, I think you don't have a duty to disclose to it. But if you lie to them, yeah, lying is the potential to void your whole policy.
Okay.
Absolutely. All right, let's go to the phones.
Oh, so you don't have to disclose it. Okay.
Only if you're asked.
To the insurance
Yes.
company.
What do we got, Rob?
All right, let's go to Eric in Indian Harbor Beach, if that's right.
IHB.
Eric?
Hello, Eric. Thanks
Hey,
for
how
taking
are
my
you?
Call.
Good morning.
Good morning. This question probably involves everybody in Florida.
Sure.
We have a $70,000 assessment on our condominiums here, and I'd say about 20% of the owners are senior citizens and disabled who cannot come up with the $70,000, and this is their homestead in Florida. Can they be evicted? Because they claim they can't get any more loans on their property.
Yes, they can get evicted. When you say it's not, the term is not really evicted. If the association passes a special assessment or just increases the regular monthly assessments, and any unit owner is not paying them and they were passed properly, then yes, the association has eventually a right to foreclose on their unit. Absolutely. And you're saying that they...
I'm
Go ahead.
sorry.
No. Your point was also that they can't borrow any more money on their unit. You know, I think if you take the 55 and over communities, I think I'd be really surprised if anything less than 80% of those units didn't have their units completely paid off. I'd be really surprised at that. And, you know, I don't know what to say. I don't know if you're a new listener or whatever, but this is something we talk about on the show week in and week out, that especially the older people, the 55 and over communities, they've waived reserves, not just year after year, they've waived it decade after decade. So, you know, myself, and I got to tell you, the Florida legislature too, I don't know if I have much sympathy for people that waive it decade after decade. I mean, you have to start thinking eventually this building's going to need repairs. And the joke always is, you know, you didn't think you were going to live long enough to see the money you were putting in your reserve account. But unfortunately for you, you did. And now it's time to make the repairs.
If someone, Julian says, it's a shame here, your building's 50 years old, you're lucky. In Italy, they last 1,000 years.
Right, exactly, because they used real materials back then. They used stone, and what do we use here? You know, the cheapest thing to put up a building as fast as we can.
Chinese drywall.
Yeah, so, you know, I understand how you're feeling. I understand your concern for your community, but what are you going to do? The buildings need to be fixed, you know, and you have to fix them. And it's not the responsibility to fix them on anybody else other than you. You know, I was at a function about 2 months ago, and I'm not going to say where I was, but the people in that were in the audience were basically saying, well, what we need to do is have a new tax on the working people of the state of Florida so that they can give us the money to fix our condominiums that we didn't fix for the past 30 years. And I'm like, really? Is that really what you're thinking, that the working people of Florida should get taxed so that their money should go to pay your condominiums that you refuse to fix for decades on end?
That you're living in.
Yeah, that you're living in, right. So I don't see that, you know, I don't see that as a solution, and I certainly don't see the Florida legislature thinking that that's a solution. Easy way to get voted out of office real quick.
By
Who
the
else
way,
we got, Rob?
Someone's asking when the name of the publication that...
Florida Community Association Journal. FLCAJ. Who else we got, Rob?
Let's go to John in Tampa.
John.
How are you, John?
Hey, Eric, thanks for taking my call.
Sure
I guess
thing.
I will gladly withdraw my BOIR.
Yes.
Since that's a dead issue, and I'm very happy to hear that. That simplifies absolutely everything.
It's been such a joke over the last few months. It was embarrassing, really.
So the other quick question I had is, my documents have always said the annual meeting, budget meeting, is a 30-day notice, but I keep seeing online some places say it's only 14 days.
You in a condo or an HOA?
HOA.
Yeah, 14. Correct. That's correct.
So for an annual budget meeting, if my documents say 30 because the statute is less time.
Well, let's hold on. A budget meeting is something different. Hold on. Budget meeting is absolutely is something different, actually. A budget meeting, there's nothing in the statute whatsoever that says that you have to give advance notice other than any regular board meeting.
And you can combine it with your annual meeting, yeah?
You can, yes, but there's nothing in the HOA statute that says a budget meeting has to get any special notice. So yes, and matter of fact, the same thing with your annual meeting. It goes by what is in your governing documents when it comes to an HOA. And what is in your governing documents when it comes to an HOA?
Our annual meeting is 30 days.
It's 30 days. Okay, then follow what it says in your governing documents for an HOA. For a condo, special meetings like a budget meeting, 14-day notice. And annual meetings in a condo is totally different. You got to give a 60-day notice. So.
Yes, I did see that, but I'm glad I don't live in a condo.
Got it. I think a lot of people are glad.
Great for the information.
You got it. Hey, talk about the information.
In Tampa. Thank you.
You got it. Rob just put up a link to that condominium governance form, and it's on the YouTube chat box right now. So those condominiums out there who don't have it, make sure you get this form, make sure that this form is filled out, and make sure that it's kept as an official record of your condo association. Back to the phones.
So that would be on the website.
That's correct. That's a form that has to be on your website.
Okay.
That's exactly right.
Okay,
Can you put it on WhatsApp? That was a question.
No, it cannot be on WhatsApp. Go ahead.
Over to Ruth.
How are you, Ruth?
Yes, hi.
Good morning.
I live in an HOA, and last week we received a notice that we were going to be faced with a special assessment to renovate our clubhouse as well as top up the reserves. My question is there anything in the Florida statute that limits the percentage of the special assessment amount that can be assessed? This is basically 20% of our annual budget,
right?
And it was a planned expense, but the board chose to exclude it from the budget.
Okay,
it doesn't involve safety, all security. It's just aesthetic.
Okay, so hold on. So there's a lot that's been asked there. So in an HOA, unlike in a condominium, reserves don't go into your budget automatically. They get there if the documents require it, if the unit owners vote for it, and the board can put it in your budget as long as there's not a restriction that your budget can't go up over a certain amount. So the first thing you want to do is look at in your governing documents whether or not there is a restriction on the amount that your assessments can go up because of reserves. Okay, so that is where I'd start. That's really important. Now, in terms of if the properties need repair, okay, but there is a limit on how much your amounts can go up, your assessments can go up in 1 year. Courts have been ruling recently, you take that language, throw it in the garbage. It means nothing. Okay, I mean, if you had to have, think about it, if you had to have the unit owners vote to have special assessments, would they vote for it?
No.
Of course not. So we're not going to have the safety of the buildings, right, and of your community put at risk because people don't want to vote for assessments.
Was that one of the bills for condos, though, is to cap those assessments at 15%?
It can't. It
Right.
can't, because there is, and courts again have been addressing this, there is a corresponding obligation under the statutes that your board has to fix the property, period. Fix the property. And if it means that your assessments have to go up more than 10% this year, more than 15% this year, 20, whatever the number is, that board has the obligation to fix the property. If it means passing a huge special assessment, that special assessment has to get passed no matter what your governing documents say. There are no limitations. Okay?
Now, this doesn't involve, but this just involves redecorating, like replacing the floors because they don't like the design.
Okay. Now, in an
replacing
HOA,
drapes because they don't like the design.
okay. In an HOA, that is typically considered a capital improvement. Okay. Now, then you have to look at your governing documents to see if there is language that limits the amount of a capital improvement in any 1 year.
Very good.
Okay. Like it's not a repair to say, you know, we just want new furniture.
But wouldn't a capital improvement be in the budget, not a special assessment?
Not necessarily. No, it would be typically, matter of fact, typically passed by the board in one big shot.
Okay.
Yeah. And when that's done, you got to look in your declaration to see if the board is capped. And if they are for capital improvements, that's something else other than repairs. And yes, that cap would be in place.
But if there's safety concerns at the clubhouse,
Totally different. Throw all that out. Okay. If it's safety concerns, no limitation. Let's do this. Let's take our first break of the hour. Seems like we took a couple, but let's take our first break. Taking your calls, 717-452-9378. Back right after this.
Can help with every phase of the building life cycle. For mitigation after a catastrophic event, building restoration, repair and remediation consulting, or Senate Bill 4D inspections, please visit rimkiss.com.
All over the world, people have plumbing problems. These problems can be expensive and destructive to fix. Have you ever wondered if there was a way to take care of your plumbing problems without destruction and an outrageous price tag? Welcome to Pipelining Technologies, Inc., where we specialize in fixing your problems without demolition and minimum cutting by means of pipelining. Pipelining is the ability to take a pipe damaged by root intrusion or long-term deterioration and make it new. By means of inserting an epoxy-saturated liner into the pipe and allowing it to harden or cure, leaving behind a brand new pipe.
That sounds great. How can I get pipelining in my home, commercial building, or condominium?
Simply fill out our online contact form and a pipelining representative will get in touch with you in a timely fashion. Or call us directly at 561-853-5463.
Welcome back to Condo Craze and HOAs on our YouTube channel. Karen Curtis with attorney Eric Glazer. And we're taking your calls here in the studio, 717-452-9378.
All right, back to the phones.
Let's go to Shelby. I think it's Delray Beach.
Good morning, Shelby.
Oh, hang on one second. There you go.
Hello.
Good morning.
Can you hear me?
Yes.
Oh, great. Thank you. Hey, just want to first say, Eric, your name is very well renowned around here.
Thank you.
You had helped represent one of the villa's residents, and you uncovered something pretty huge, and she didn't end up following up on it a couple of years ago because she moved. But we have taken what you had started, and we're on quite a big journey. So you found out that our shared recreation board, for those people that have a shared entrance, I'm not sure if you recall, it was a couple of years ago, but we have two sides. We're an HOA, and we have homes on one side and villas on the other.
Right.
And we have a shared recreation board, but it's really it's headed by the villa's HOA.
Okay.
Because it has four representatives against two. So anyway, you found out that they had filed and incorporated as a for-profit entity 7 years ago.
I do remember something like that, right? I do. Well, thank you for saying those kind words about me on the air. I appreciate it very much.
Yeah, I would definitely. So we'd love to chat with you offline, of course. But I guess my main question, if I was just to ask a general question, is what are next steps for a community that's uncovered that a recreation board did go against the bylaws and created a for-profit entity when it should have been in
a nonprofit, and they basically locked us out of all the bank accounts.
Oh.
They've locked us out. Yeah, they've locked us out of. They won't even let us see. We had to demand to see the financials. They didn't give them all to us. But what would be, next steps to get on the bank accounts? Because that's the most important thing. They took us off, and
yeah, I mean, I would need to look at your
kind of at a crossroads
the
here.
documents again, but it may need again, if we're going under 720, it certainly doesn't seem like it's a 718 situation. It's a 720. So if it's under 720, we may have to start in a mediation. And you have the mediation statute now, where you have to give the other side notice that it's time to go to mediation. You send them this letter that says choose one of these 5 mediators, and you have to start there. If you don't start there, your case files in court, you get thrown out of court.
So
that's probably where you're starting.
if they're a for-profit, would they have to do the BOI then?
No, BOI is done. Forget it.
all right.
BOI, we never have to even mention again.
Oh, even if you're for-profit?
Forget, done. BOI is finished.
So my understanding is that they're not under the 720 statute because they are a for-profit.
Right, but the
entity,
question
they're a
is, should they
corporation.
have been? Yeah, that's the question is, should they have been? And if they should have been, the question is, what do you do about it now? And maybe you got to go to court, get injunctive relief. Again, this happened a while ago. I obviously don't remember the exact specifics.
Of course, no,
Yeah.
I wouldn't expect you to.
That's okay. But sometimes it's hard to answer questions sometimes unless you have the specific documents in front of you.
We'll give
And
you
I
a
think
call.
Here, give us a call off the air, 954-983-1112. Again, 954-983-1112. And we'd love to help you again.
Fabulous.
Okay?
Yeah, we'll
Thanks.
look forward to chatting with you this week. Again,
Thanks
my
for
name's
the kind
Shelby. You're
words.
fabulous.
Thank you
so
so
much,
appreciate it.
everybody. Bye-bye.
Thank you so much. Okay, who
Bye-bye.
else we got, Rob?
You're fabulous.
My wife should listen to this, wouldn't she? Yeah.
I'm fabulous when you go home. Tell her.
Exactly. Yeah. Throw out the garbage, idiot. Right? Go ahead.
Next call, Julia from Central Florida.
Julia.
Hello, good morning. Thank you as always. I have 2 questions, but very quickly. One, after an annual meeting, can a homeowner request copies of the proxies that were handed in to the board for the annual meeting?
Of course, proxies are absolutely an official record of the association. You can get copies of it as long as you ask for it in writing, and then you're entitled to access to those records within 10 working days. Okay, but yes,
thank you very much.
handing in proxies, proxies are an official record. Okay?
Sure, thank you.
Okay.
I appreciate it. My second question is about Zoom meetings. If an association requires that we have Zoom meetings, are the records of that, the Zoom meeting recordings, do they need to be accessible to homeowners or just the minutes of the meeting?
So there's a rule of the Florida Administrative Code that says once they're transcribed, right? And is this an HOA or a condo, by the way?
An HOA, I'm sorry.
Oh, an HOA, I'm sorry, then the administrative code don't apply. But if we're going to mirror it and we look for some guidance, then once that recording is transcribed, then you don't need the recording anymore. Do they have the right to destroy it? Probably. But let's stick on that line of questioning for a moment, because yesterday I had to research something, and the question was, can boards now, can they have a board meeting solely by Zoom? And I will tell you this, that there are a lot of boards that are doing just that now. They don't have a physical location for a meeting anymore, and it's just all Zoom, period. And there's arbitration cases for condominiums that say, no good. You always...
They can be at home and, relax and watch the game.
I can tell you this, again, what I'm telling you is decisions done by arbitrators for condominiums. And in the condominium setting, that's the case. The board meetings cannot be solely by Zoom. In an HOA settings, again, it's not governed by the arbitration decisions other than election and recall meetings. And I believe there was an HOA case that says for recall meetings, right? The board has to have a recall meeting within 5 days after getting served. Even that meeting needs to be at a physical location. They can't do it by way of just Zoom. So if I was advising HOAs or condos, what would I say? You have to have that meeting with a physical location. Again, like I always, I mentioned my mom, 93 years old, doesn't know how to use Zoom. She wants to go to her meeting. Doesn't she have a right to go?
Some people don't have computers.
Exactly. Right.
Well, you can use your phone, though,
exactly.
right?
So, yeah, so we always have to think
Right.
that way.
And Zoom did come around.
Yeah. What about the person that doesn't have the ability?
And keeping the records of Zoom meetings, that's a lot of, space to take up, on
Exactly. You know, I'll tell you, as long as we're on that topic.
And mute everyone.
I had, and we did when did we do that blog, Rob, about AI, right? It was this week, right? We did the AI blog this week, right? AI. An interesting blog about how AI is going to be changing how condos work, and it's already changing everything. So I have a Zoom call this week with a client to discuss their case, right? And I hang up the phone. We met for like 20 minutes, I'd say. Almost instantaneously upon hanging up the phone, I get an email from Zoom. I'm like, what's this?
It transcribed your call.
Not word for word, better. It said, this is what you've spoken about, this is what your issue was, this is your client's responsibilities going forward, this is your responsibility.
Did you ask it to do that?
I did not. There was obviously some feature that was on that I didn't know.
Yeah.
And I'm like, this is insane.
But
I felt like I was violating attorney-client privilege.
Yes.
Was I? I don't know. I mean, it wasn't a third party that was listening to it, but it was.
Well, it was
felt
emailed to
very.
you.
It was emailed to me. Bizarre.
So then you're not violating. But if it's emailed like
so if it was emailed to a third party, yes, then I'm in big trouble.
But wouldn't you prefer that rather than the client just going to AI and asking the question they asked you to AI and getting the answer?
You know what? I'll tell you. Originally, when this was over, I've said, "Oh my God, this is terrible. This stinks. This is bad." I felt like somebody was spying on us, and then I had time to calm down and I thought about it. I said, "You know what? What's so bad about this?"
I thought it was great.
It summarized what we spoke about. I now have a record of what we spoke about. If we both consent, right? I mean, I'd like to know what some of you think about it out there. If you're having a conversation with your counsel, right, would you mind if AI was listening and then kind of transcribe the call in AI terms, right?
So they can use AI in the courtroom rather than a stenographer.
Not yet. Not
Can you
yet.
imagine?
Not yet. We're not there yet. But one day, possibly, absolutely. Did I cut this young lady off? I don't remember if I
She's here.
did.
She's hello.
Oh, we're still
No,
there.
I'm there. But
Okay.
Thank you so much, Eric, for that wealth of knowledge and information.
Thank you
I
so much.
appreciate it
Thanks
so
for
much.
listening and tuning in. You got it.
Yeah.
Who else we got, Rob?
All right, go to Patrick in Sarasota.
Hey, Patrick.
Hi, thank you very much. I'm such a fan of you guys and so grateful for
Thank
everything.
you. Thank you so
for the
much.
knowledge you
Appreciate
give.
it.
There's great snippets all the time. Thanks. Yesterday, on Saturday, the association had a bunch of contractors here, and it's against our regulations to have contractors working on Saturday and Sunday. The board president then came up to me, and I told her, well, you guys are violating the rules. I'm a rule stickler. And then she said, I'll be careful how I say it. You will always be an AH. I'm sure you could use your imagination.
She called you that?
Hello?
Yeah, did she call you that? Is that what you're saying?
Yeah, she called me that. I always use every bit of politeness that I can. It's not a good HOA.
Right. Well,
or condo association.
Okay. And your question is?
My question is, she fights with other people, demanding protection orders. She runs the place like she owns it, like it's Appalachian Motel 6. And I don't know how I should report? How do I report this?
If you don't, there's only one way. When you say report it, if she's not doing anything criminal, right, there's nothing to report. If you don't like the fact that she's on the board and you think she's nuts, you got two choices. A, run for the board. Well, three choices. Vote her out in favor of somebody else, or do a recall, right? And if 50% plus one of the people don't like her and feel the exact way you do, then they're going to vote her out. That's the bottom line. But other than that, unless somebody's doing something criminal, there is nothing to report, nobody to report it to, or unless they're violating specific provisions of 718 or that you can report to the DBPR. Other than that, nothing you can do, my friend. Okay, but
thank you very much, and thank you both gratefully for everything you do.
Thank you very much. I forgot we got one more break to take.
Yeah.
Okay, let's do that. Be back right after this. 717-452-9378.
In South Florida, the transition from bright sunshine to heavy rain and hurricanes can take a toll on your property's exterior and structural integrity. Cracked stucco, spalled concrete, they're more than eyesores. They can signal deeper issues. Now, with new Florida laws involving structural integrity requirements, we want to help you meet your milestone inspections and maintain the durability and beauty of your building. Since 2004, PD has been the trusted expert in structural concrete restoration, painting, and waterproofing for condominiums and commercial properties. Visit pd-concrete.com or call us today.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project. Visit us online at dmipavingandsealcoating.com.
All right, welcome back to our final segment of Condo Craze and HOAs here on our YouTube channel. This is Skippy, the show's dog. And we were just coming up, apparently Robert looked into this Zoom thing and they can encrypt the discussion so that it doesn't go to a third party. So that's good.
That is good.
Yeah, and then...
look at this. I don't like what, excuse me, what Google writes in. AI may take the place of an attorney.
Yeah.
Damn, objection. I don't like that. Not that
no,
person,
but it'll take the place of all of us. As Elon Musk says, things are about to get really weird.
I agree. I can certainly see
it's already
it.
getting weird.
I can certainly see it. I mean, I know you had a personal thing where I can certainly see taking the place of doctors in some.
Yeah, I uploaded my dad's CAT scan for his lung cancer, and it told me exactly what was going on because the doctors weren't telling me. And then finally they did, and I'm like, I already knew that. And they're like, oh, you had that ability to do that, to upload the image? I'm like, yeah, they didn't even know they could do it.
Insane to me. So you uploaded the image to artificial intelligence,
and it told me
it
exactly. It's a 90-year-old patient. It was like unbelievable.
That is
the detail.
That's frightening. So you're not going to need radiologists after a while?
No.
Scary.
I think we still need human oversight.
Including Robert. Somebody's got to answer the phones. To you, Rob.
All right, next call would be John from Tampa.
Hey, John.
Hi, guys. How are you?
Okay, how can we help?
Question, real quick. Closed board meetings, I understand the need for them. We always get notified by agenda that they're having a closed board meeting.
Yes.
Are they required to provide us at least who attended the meeting?
Do they have to let you know who attended the meeting? No,
Yeah.
there's nothing that I'm aware of that requires them to let you know who attended the meeting. No, the only thing that they're
Dang.
required to do is post notice of the meeting. Even though that it's a closed door meeting, they still have to post notice of it. Okay?
Okay. once a lawsuit is over, do they have to post the results of each of those meetings or no?
No, they do not. And this is a topic that came up amongst the board certified attorneys this week. There's a provision of the statute that says, of course, attorney-client privileged communications cannot be seen by other owners, but there's another provision of the statute that says once that's over with, like this gentleman is referring to, everybody can see those communications. And that is like, goes against, here we were talking a minute ago about privileged attorney-client communications. That goes against everything that attorneys stand for,
Right.
against a long-standing history of attorney-client privilege. We find it bizarre that even though the topic has now been settled, that you can now see the attorney's mental impressions, thoughts, conclusions. It's bizarre. And there was some talk on this chat as to whether or not it actually means what it says what it means.
Yes.
So, because we all find it hard to believe that it just can't be
It's
that.
not 100% accurate yet because it's still getting information put into it all the time.
Yes.
And some information is going to be wrong.
Because I know our board is taking up issues that are not legally protected through a closed board meeting, and that kind of opens that question to other, what are they required to provide to us?
So they could be meeting with the attorney to discuss pending or imminent litigation or administrative proceedings, criminal proceedings, something like that. But they just can't have a closed door meeting with the attorney and talk about anything. That's true. That's correct.
And they can't vote on anything.
Correct.
Yeah, I know, and that's exactly what they've done.
Oh, they voted.
They took a Oh, yes, they did. And I have proof of it.
Well, I can see if it was a vote to proceed with a lawsuit, proceed to defend a lawsuit, something along those lines. Yes, I think that would be perfectly fine. But if it's something other than that, I don't think that
it
they
was
can do that.
something other. Essentially, it was during a closed meeting to allow another HOA to use our clubhouse at no cost.
No, there's no question that that's something that the unit owner should be able to see the board vote in favor of, and they have the right to talk about it and opine on that as well.
Can they let another HOA use their clubhouse anyway?
I don't know. I'd have to look at the only way to me to do that is to look at their deck. So
I don't have a problem with the other HOA using the clubhouse. It's just that they decided to let them do it for free.
For free. That's the problem.
Meanwhile,
why? The question is, why would you
that's the
allow
problem.
it? Yeah. I mean, you guys should be getting something in exchange for that. No? Makes no sense. All right, we got to run. Back to the phones, Rob.
Bye.
Thank you.
Next caller is Nikki from Cricket Club. Famous Cricket Club.
How are you, Nikki?
Hi there. I'm good. Can you hear me okay?
Yes. I believe the Cricket Club was the one in the Miami Herald last week, right? Yes.
It was.
$56 million assessment?
Nikki, you're getting hit hard with special assessments, I understand.
We are, but the good thing is that we're ahead of most other places. So the assessment's in place. We've been collecting it, and we're working on fixing everything. So it's hard on us, but we're actually moving forward.
Okay.
But that's not what my question is about. But
Sure.
I wanted you to know we've done a good job of moving that forward.
Good for you. How can we
Done a
help?
good job. So my question is about the board some time ago changed the use of several rooms. And in that change, it's actually causing noise now. So when they made the change, they moved a gym from the basement to another floor that sits under a bunch of units. And I'm one of those. I'm 2 floors up and I hear noise from the gym.
Yeah.
And they also moved, we had a quiet restaurant and now it's like a party room. So people hire DJs and it's loud and thumping into the units above that.
Sounds
So
like a
when they
nuisance.
made those moves, they didn't do any sort of review of what needs to happen.
Sure.
And when I bought, and that was, it's been written about in some of the minutes of board meetings. And then I bought after this, it's kind of complicated story, but I bought after this. And now I'm sitting with a unit that gets a fair amount of noise from the gym. And while we've been trying to sort it out, my question is, what kind of responsibility does the association have to make it okay for units that sit above a room like that?
Well, Karen, I just alluded to it, that what's happening in your unit is that the board has created a nuisance. And just because they changed the location of the gym or other rooms or restaurants, whatever it may be, that doesn't mean that they have the right to now cause sound in your unit that you can't live with. Maybe they need to go back and put certain soundproofing materials in, right? Or then maybe they need to soundproof your unit in a better way. But there definitely needs to be an ability by the association to take care of this problem. If not, make them buy the unit from you and use it for one of those things as well. But you shouldn't have to suffer with a noise problem because of the changes that they made. That's for sure. I mean, that's a given.
Even though the changes were made several years and people have been complaining about years and nothing happened.
Well, you just moved in, you know, and if they failed to do anything about it for many years, well, they might have blown the statute of limitations. I don't think you did, because this problem exists, you know, you just moved in.
That probably should have been disclosed to her too, don't you think?
Maybe by the seller of her unit, maybe from the seller. But
well, the seller was an older lady that had died, so I bought the unit from her daughter. So she wasn't around to tell me.
I got it. Well, bottom line is, if you're living with a nuisance and you can't take the noise, I think the association still has a duty to you to make that noise go away.
You don't have a clubhouse?
Make an effort. Yeah, no two ways about it.
You don't have a clubhouse? Why is this stuff not in a clubhouse?
We kind of do, but I don't know. They moved it right underneath the units, and I'm 2 floors up. The lady beneath me is like having more noise.
Right, she's probably going even
so
crazy.
That's what I wanted to know. If we had something to say, you got to fix this. You can't just keep ignoring it.
Absolutely. Okay, that's my 2 cents. Okay.
Great. Thank you.
Right.
It was a great conversation. Thank you. I just said to the board members, I think we need to put you on in the board Sunday mornings for coffee and tea so everybody can.
Yay!
So, as a matter of fact, a lot of times at the seminars, people will come up to me and say, yeah, our board gets together on the Sunday and listens to it together in someone's house.
It's not a meeting.
It's not a meeting. No, not if they're just listening. Correct.
And if they're having strawberries and cream, it's definitely not a meeting.
Definitely not a meeting. Hey, on that note, ladies and gentlemen, thank you. That brings us to the end. Thank you so much. Brings us to the end of another show. If you need legal help off the air, give Glazer and Sachs a call. 954-983-1112. Again, 954-983-1112. Of course, we'll see and speak to you again next Sunday at 11 a.m. on Condo Craze and HOAs. Everybody have a wonderful, healthy, safe week. Take care, everybody.
Thank you.